Yes, 25.
You don't have the devices we ordered you to do?
No, sir. I have I have a letter from the State Department of Transportation in Austin saying I am
No, no,
not
no, no,
ordered
no.
to drive a car, so I figured I didn't have to get it. So I can't drive. I didn't know. I didn't know. After since I can't drive, why should I get it?
Classic mistake. Thinking a letter from the DMV overrides a judge's order. Spoiler, it doesn't. The court isn't asking, it's commanding. When you ignore a bond condition, you're basically daring the judge to throw you in jail. Would you call this arrogance or just ignorance?
And then
Because I ordered you to get it. And now I'm revoking your bond and I'm putting you in jail because you've been a whole month without having it. You decide on your own? Courts don't work like that. It goes with you.
Thank you, Judge.
Well, Mr. Kim's on Zoom. I'm approaching, I spoke with my client. My client would like me to approach to ask for a bond so he could go and turn himself into the demanding jurisdiction, Worcester County, Maryland. And so
What's the last name?
his last name is Mr. Baptiste, P-A-P.
Good morning, Mr. Baptiste.
Good morning. How you doing?
So I don't know, I don't know anything about you. I don't know what you're wanted for. I don't know what kind of criminal history you have. A lot of times, whether we give a bond to someone depends on what they're charged with, what kind of criminal history they have. I know that you're going to tell me it's little bunnies jumping in the woods, but everybody tells me this guy's purple,
Understand that?
blue, black. So, but paper really tells me who you are because that's how we get to know you in the short time that we have.
No problem.
Mr. Kim, would you like to tell me about him?
Your Honor, he's wanted out of Yavapai County, Arizona for 6 charges, including fraudulent schemes and artifices.
Wrong case.
Wrong
case.
Oh, sorry, wrong case. He's wanted out of Pasco, Florida for battered prior.
Wrong case.
0 for 2, man.
Where are the ones?
Baptiste.
Maryland.
Hold on 1 second, please.
Whoa, this isn't small-time shoplifting. We're talking tens of thousands through wire fraud and stolen IDs. Courts take financial crimes seriously because they're premeditated and often tied to organized schemes. Question for you. Should nonviolent fraud get the same harsh treatment as violent crimes, or does the dollar amount make it just as dangerous?
Oh, here we go. Sorry, I was reading a different warrant. Okay, he's wanted out of Worcester County, Maryland for theft, but he's wanted out of 6 charges. 1, 2, 3, 4, 5, 6 charges, including fraudulently intending another's identity to use that information to obtain a value of item and currency totaling a little north of $80,000. He's currently on a deferred adjudication for an aggravated assault. And prior to entering in the deferred adjudication, but after he was charged, he was also charged with carrying a handgun in a motor vehicle. State would be opposed to a bond, Judge.
So, okay, you went kind of fast on. So he has 6 open charges in Maryland or just 2?
Yes. So he has 1 count of $21,455.50. He has another count of $10,700. He has another count of $10,695.50. Another count of $42,851. One count of fraudulently intending a possession of personally identifying information, and another of fraudulently intending to obtain another item of or identity, assuming an identity of another individual to obtain an item of value.
Are all these? Is it like a theft from a person?
It was a fictitious wire transfer for at least one of them. I'm looking at the affidavits. One is routed through PNC
Do we have
Bank.
actual complaining witnesses or victims, especially on the one that's like a 40,000 gig?
That one I can hold on. Here's an account withdrawal. I mean, I can't tell if it's from the bank or from another. If I could just have 30 seconds, I'll take a look at the.
And how old are these cases? Are they new or are they old?
These are relatively new, Judge. This one is from June of 2023. So obviously it was after he entered in the deferred adjudication for the aggravated assault. Obviously violating his conditions of the aggravated assault. Let
me tell you the problem that I have, Mr. Baptiste.
Okay.
And the way you conduct yourselves in court, and And the way that you conduct yourself while you're on probation tells me a lot of who you are and whether you will submit and comply with court orders. Because one of the things that we have is when I give you a bond, you have to go turn yourself in to the demanding jurisdiction within 2 weeks.
That's no problem.
Great. Well, the first thing I did was I wanted to look through your history with the probation that you're on. And in the first thing that I pulled up in this bond violation report, I have here, 5th violation report submitted for failing to report to the bond unit as scheduled. This is the alleged probation that you're on.
That was way.
Stop. I
Okay.
don't want you to explain anything.
I know.
The only thing I'm trying to impart to you is the way that you've been on your probation and the fact that you've picked up the 6 cases in Maryland in 23 or 24, whatever it is, and the amount that it is, tells me that it scares me to give you a bond because I don't think that you will comply. And it's unfortunate because I don't like to keep people in, but the reality is paper tells me who you are. And all those bond violation reports, the 6 new cases.
That's
Sorry.
one of the things, if I may, the
Sure.
6 cases, it doesn't make a distinction whether there's 6 separate transactions or it's all one happening at one time. And so he hasn't been able to answer for that. This is only from 2023. He would like an opportunity to do so. He is going to work out his felony case when he gets there. Up there tomorrow, he's going to have a chance to work it out. I don't know if he'll be able to work it out or not, but it's his first opportunity to do so tomorrow. If he makes bond up there, would you consider giving a bond then?
No.
No?
It's just the way that the probation has played out and the fact that he has 6 here. I think in my heart of hearts, if I set you a bond, that it's just, you're not going to show up. You're going to do what you want to do because that's what history tells us.
Okay.
Okay.
Sorry.
I understand you. Thank you.
Okay.
No question. Would you mind explaining to me?
This is not, no. This isn't where you get to do what you want to do.
That's cool. All right. Thank you.
Ask your lawyer, and then if it's something, we can talk.
Thank you, Judge.
Thanks. So tell me what we're doing with this.
Judge, this is a fugitive case. Mr. Day, I believe, is on Zoom. I am requesting to see if you would consider giving him a bond so he can go turn himself into,
para que él se entregue
it's Yerpe County, Arizona.
a Yerpe, el condado de Yerpe en Arizona.
The lawyer is asking for me to set you a bond, Mr. Pasos Miranda. I don't know.
No sé.
I have to look at several things to see whether you would be a good candidate.
A ver si eres buen candidato.
Number 1, whether you would actually go back.
¿No?
Number 2, are you a danger to our public?
Segundo, eres.
So Mr. Kim, tell me about Mr. Pasos, please.
Quiero saber sobre el señor Pasos, señor Ken.
Yes, Judge. This is the one from Yavapai County, Arizona,
Es que este es de País County, Arizona.
and he's wanted for charges of fraudulent schemes and artifices.
Por
fraudulent what?
Schemes and artifices. This is just how it's written.
Schemes and artifices?
Fraudulent conspiracy to commit fraudulent schemes and artifices.
cometer
Okay.
fraude,
One count of computer tampering,
artificios, parece.
one count of theft,
Una cuenta de alterar computadoras.
and one count of criminal damage.
Uno de daño criminal.
So 4 total counts.
But it's out of the same transaction, Judge,
Falsos.
on
Sí,
March 20,
por la misma
2023.
transacción que ocurrió en marzo 20 de 2023.
State would be opposed to a bond.
El Estado no está de acuerdo con una fianza.
For these charges, it looks like he messed with fuel pumps at a mini mart.
Estaba haciendo algo con las bombas de petroleras ahí en un minimart,
To include computer tampering,
incluyendo que estabas alterando algo con las computadoras.
but 1 year after he committed these offenses, he
Un año
also was
después
charged
que
here.
cometió este delito, también lo acusaron aquí.
for a similar offense of violating motor fuel tax requirements.
Por violar los requerimientos de impuestos de petróleo de
And-
vehículos.
And here before that,
Y antes de
for
eso,
a misdemeanor charge of theft, but again,
un delito
regarding
menor de
fuel.
hurto, pero igualmente era de
He
petróleo.
also has a prior fugitive case, I see.
Tiene un caso antes de
I
fuga.
didn't see that when I pulled it up.
From 10/31/24, I see a prior fugitive case out of the same jurisdiction.
En la misma jurisdicción.
Yavapai County.
Yavapai County.
So he's been before you is what you're
No,
saying?
it would happen if he was
No, lo que
a
dice
fugitive and he
que
was
era
apprehended
fugitivo
by another
y
state.
agarró otro estado.
It could have been by this warrant or another warrant,
Pudo haber sido estado de un arresto o otro.
Oh,
Una
be-
otra
but
arresto.
because it's resolved, that's why it's closed on our end, and I
but let me
can't
ask you
find
this.
it.
Did he know about this in 2024? Because if he did, I'm not giving him a box.
He's saying he didn't know, Judge.
I see state jail. So I see a fugitive case and I see a state jail sentence of 7 months, both on the same time out of work.
Estatal de 7 meses.
So it looks like there
Entonces,
possibly could have been something that he pled to in Wharton County.
se declaró
He got
algo
also
en
hit with
Wharton
fugitive
County.
case.
Y le
Because he
dio un
got
caso
7 month
fugitivo
sentence, they
y
probably,
como recibiste 7 meses.
Fugitive case.
No fueron. con el
This is a
caso
lot of,
fugitivo.
we don't really know what happened.
So let's do this. Let's roll it to tomorrow.
I've had him in felony,
Dice
and
que
I
yo
know that he
estado
pled
en el
to
caso
the
de
7 month
felonía.
stay jail.
Sé que
And then
te
he was brought over
declaraste
to Harris
culpable.
I don't know if that helps, but
7 meses.
I
en la
Represent him on the fuel tax in the 185th?
cárcel. Ahí
Yes.
es donde voy
Oh my
a-
He
goodness.
did.
What are the
That's
odds?
just opportune.
Huh?
That's why I'm like, if,
Just go play the lottery.
so, if that help, I don't know if that helps, but he was
So-
brought over.
Ella fue
from-
tu abogado, dice.
Sí,
Está hablando.
Did he do 7 months state jail? Because I show a sentence
No,
of
that's
7
still
months.
pending. So they're
No,
going to
dice que
send
se
him,
está pendiente.
Still pending.
todavía.
right.
7 meses de
Yes.
cárcel.
I know.
No,
Sorry.
there is ya terminaste, because when I had him, there was a hold. ¿Ya terminaste con el caso in Wharton County?
Yes.
Okay, because when I had him, he still had a hold. If there is no more
They
hold, that means.
run an
they're sending-
NCIC?
Yes. How to call it.
No.
I don't show
Watch
show
the-
another hold right now. I mean, there might be a warrant, but it's not attached to a spin that I can see.
It was
Ellos
there
no
when
ven
I had
ninguna
him,
What did he
Judge.
have in Wharton County?
Que tenía un.
If anything.
Other words, tenía algo.
It would have been a credit card or debit abuse. He was
Pero que
convicted
Uso de tarjeta de crédito. Por de-
on
It's
October
the same
15,
thing over and
2024.
over and over, you know?
It
It's over and over.
Y dice que no lo puede hacer porque es la
They-
misma cosa de
it's-
vuelta y de
It
vuelta.
appears to me that Mr. Pasos Miranda continues to pick up the case
Sigue
over
agarrando
and over
los
and
mismos
over.
casos.
These fuel tax
Igual,
violations
igual,
where they
igual,
they allegedly get,
violación de-
you know what I mean?
Sí, pero-
So we've got one in Wharton, we've got one here, now we've got one in Yavapai County.
Se llama Pan County.
So is it because of the types of cases he's picking up, or
Not
are we
this
going
one,
back?
but
tipo de
it keeps happening.
Okay.
Like,
Sí,
it's
no es por el tipo de caso, es porque sigue
over and over and over for the last three plus years.
What I was gonna do,
Por
I thought we were
años,
going in a manner where I needed to figure out if he was aware of the warrant or not. But if that's not the case and it doesn't make a difference,
Judge, may I jump in again?
Of course.
It looks like they lifted the hold
Parece que
on 218.
te quitaron.
If I'm looking on the DA portal,
Dos.
They placed a
18.
hold on him
Porque
on
pusieron
October
una orden de
31st,
detención
2024 for that
31 de
sentence for
octubre
7
Para
months
la
state jail.
sentencia de
And then
7
they lifted
meses.
that hold
Después lo
on 218.
levantaron en
So he's
2,
done with that
18.
as of
Él ya
218.
terminó con el
With,
18.
yes,
de
I can show
febrero.
it to you. Well, I don't know if I can.
How?
show- Because he came in on a warrant, so his time would have
Él vino
ran
en
concurrent
una
while he was in
orden
Harris
de
County
arresto.
and we were
Entonces,
working
So
out.
you know what it is? It must have been, you know, how on out-of-county cases, they give you the 10-day, right? And if they don't come pick you up, they release the whole within 10 days. That's what. it's
No,
probably-
well, so sorry, Judge. For this one, for the one on February 18th, that's for our 185th violation of motor fuel tax. That one, the release hold was on February 18, 2025. And then that triggered the in-county extradition for likely Wharton County for the out of county. That one was released on February 21st, 2025.
La orden esa te la quitaron.
But effectively, both of them, because they're state jail, it would have run concurrent. And at this point, based on when he was taken in, it's likely time served.
Which would be taking care of the Wharton County, and Wharton County is no longer in play because of the time he spent.
We don't know
in
that
here.
for sure, though.
We know that, well,
You
yeah.
know, right? So let's do this. Can we roll it to tomorrow and you can try to figure out?
Yeah, let
So
me
we have
figure
a
out.
concrete, you know?
Let me get everything in place. I'll roll it, try to get some confirmation on Wharton and figure out if he had knowledge of this case out there.
I mean, I have a concern if he knows that this is open, because it's been open since 23.
Right.
Él sabe, de hecho está abierto desde
I have a problem.
I get it.
2023
I'm gonna
que tenía
continue
una
to,
orden
like,
de-
Okay.
Let him slide when he knows he knows it's open.
y
Let me get all
sabía
this
que
in
estaba
place and
abierto.
we'll reapproach. Okay, let's do that.
Bueno, deja de hablar con él.
Okay, thank you, Judge.
Okay,
Thank you, Judge.
thanks.
I'm here on two cases. The first one's on the docket, Malveaux, Malveaux. Judge, this is the one we approached, and I've been back a couple of times trying to amend the condition for the mom. This is an alleged assault, family violence between a mother and a son. Ms. Malveaux is here. The state has agreed, and I think they've contacted someone to change her bond condition to, we were just going to ask to allow for the texting and the phone call. And then you would ask them to do some follow-up rips.
So the defendant is mom,
Yes,
complaining witness's daughter.
this is the, I believe,
Daughter's
15.
21 or 20?
Son,
The son is, he's 18, I believe he's a senior in high school. He's living with a family friend right now. And we are okay with amending bond conditions to allow communications over cell phones, so they can still text and call. But we would ask the court to
So-
hold any in-person contact.
and Judge, we would ask to allow her to go to his sporting events. No contact with him there, but she'd like to go watch him at track.
Now, I mean, it's
And the
invariably
football.
going to happen where she's going to get overcome with emotion. Then she's there. He's 2 feet from her.
Judge, he'd be
Know what I
on the
mean?
field and she'd be
It's
in the
like-
stand.
It's like holding a candy in front of a baby. I'm sorry, not a baby, but like a 13-year-old kid.
Judge,
you
I
know?
believe she could stay in the stands. and he'd
Malveaux,
be
come
on-
up.
And he'd be on the field, but
I don't know. I mean, I don't think that's
Jose Montes?
it's setting up for failure right now. The only thing I want in the short life while I'm here is to protect every single complaining witness in these cases, in this county, in this state, as much as I can. And the problem is that temptation is so very high. We have at this moment a no contact order. You're not supposed to have any contact with this person. Your lawyer's asking for me now to allow you to have contact and texting privileges so that you guys can have some kind of communication. The state is still opposed to having you in-person contact. And the problem is that if you go to, and I'm inclined to, agree about in-person contact. The problem is that if we allow you to go to these sporting events and he's 2 feet away from you, the temptation is so high, it's invariably going to happen. And we're not there to see whether it happens or not. And so therein lies the problem, is that I will never be able to monitor the fact whether you actually have contact with this person or not. And that's a problem, because the last thing I want is you to pick up more cases or this person to get more hurt.
talking about in person.
Yep, you heard that right. A mom biting her teenage son. This isn't just bizarre, it's a legal nightmare. Domestic violence laws don't care if it's a punch, a slap, or a bite, it all counts. But here's the twist. Was she lashing, out in anger, or reacting while restrained? Do you think intent matters in cases like this, or should the act itself be enough for conviction?
Y'all have him as 18?
We actually have him in the up there rib face 16.
Yes, Judge, he's 16. He's not 18.
The birth date was listed wrong.
It's okay.
And his father's in jail.
Remind me about the assault, please.
Sorry, Your Honor.
Refresh me about the assault, please. How bad? We're talking.
Yes, Your Honor. So the assault took place in June 2024, and the victim was identified and the victim explained how his mother, the defendant, assaulted him by biting.
Biting.
Yes, Judge.
It?
You see. So the victim stated his mother was angry that he was in the way, and as he was holding her two wrists, she raised her hand up to her mouth and raised his hand up to her mouth and bit his hand. The victim stated he felt pain, was in fear, and the victim had a visible bite mark on his hand.
Judge, the son is holding her first, just so we're clear on what's happening.
I mean,
Yeah,
Yes,
but
it does
he's
state
not
that.
quite saying that.
Well, it does
I
state
mean,
fully
what
that.
circumstances happen to where a 15-year-old grabs mom, right? I mean, perhaps they were fighting, I don't know, but the fact
Judge,
remains is that
there's been no facts and nothing in the probable cause that I've been given or that I've shown that any of this was between the mother and the son. I believe it was between my client and another lady, and the son comes and holds her. I believe that's what the
So-
facts will bear out.
he's trying to protect her. He's trying to, I guess, de-escalate the situation.
Judge, I believe that those would be facts that I would want to
Right,
try.
I mean,
yeah.
I don't know,
Right.
and so, right, same thing, I mean,
Those would be
regardless, what we
facts
do
that
know,
I'd want to bear out, but it's not like she just walked. I didn't want when you're making your decision for you to be basing it on what it sounds like she walked up to him and bit him. That's not how it happened.
I get it, thank
Thank
you.
you. Thank
Because,
you.
and, I mean, the idea is that we really want to know under what circumstances everything happens. That's why with every case that we have here, we really delve into it as deep as we can to determine, is there a probable cause? What circumstance should we have as far as contact or no contact? Guys, what do you think?
Judge, we're okay with them texting and calling each other just to catch up.
What does he want? I mean, at the end of the day,
So
we need to find out what he
It's a little bit of
wants.
a complicated situation in terms of the complainant's guardian, because he is 15 and said he's living with a family friend.
16.
What we do know is that he does not want to be living with the complainant, with the defendant. He wants eventually, I think his eventual goal is to get emancipated. We do know that. We talked to the person that she's living with and says that they have been texting already. So because of that, we're okay and that they're
Are you
okay. with
texting
it.
already in violation of a no contact order? If that's the case, I mean, I've got it. We'll take issue with that.
So this was based on the talking to this parent. She wasn't entirely sure.
Do we have a no contact order now?
I'm not entirely sure. And the other thing is that we haven't confirmed that with the complainant itself, the 15-year-old. So at this point, we don't have evidence to move on a
Right.
violation of a corrective order or anything at that point. But it seems like the kid is okay with calling and texting, but hasn't.
But you don't know that
They
for
don't-
sure, though. You don't know that for sure, right?
That's correct.
And Judge, as of December 18th, 2024, there was a no contact order in place.
I hope that you're not having contact with this
I'm
person.
not having that.
I hope, just, let's do this. Why don't we set this off for a couple of days? If you could please reach out. I want to know what he wants or she wants.
Judge,
Teenager in school is really hard.
I want to honor the complaining witness's wishes.
we've,
And this is that they just don't know.
well, Judge, can I just recount this? We've been asking them to know this. This is the very first time I was appointed, I approached you on this. You asked them the exact same questions. They've done nothing. They can't get in touch with the complaining witness. I came back on February 2nd. I came back on February 3rd. I came back on February 10th. I came back on February 11th. I came back on February
I mean,
12th.
I agree with her. That's kind of, that's,
And that's why at this point, they are agreeing to have that full connection, which is what.
but you still don't know.
We have talked to the guardian, we just haven't been able to talk to the kid. The legal guardian is an aunt who does not live with the complainant. Who we're talking to was a family friend, we've talked to her, we've given her multiple calls.
So,
We just haven't been able to get.
so let's do this.
Judge,
Let's,
that's a misstatement. The sister's not the legal guardian. The son is living with a family friend right now. His father's in jail.
the complaining witness is a boy or is it a girl?
He's living with a
It's the boy.
schoolmate,
A
Judge.
a friend from school.
He's living with a friend from
His
school.
dad dropped him
And she's
there.
going to do a
and went to
BIP. The
jail.
chief has offered a BIP and dismiss.
I get it. I understand.
A BIP in a parenting house. Sorry. He did tell me that, Judge.
I understand, but I always want to honor the complaining witness's wishes, right? So let's do this. I do find it unreasonable that they've been here as many times as they have, and you guys have been unable to do this. So what I would suggest is do this. Reach out to them and say that we're going to subpoena them to come to court if they did not get in contact with you guys. Because I agree with you that it's unreasonable to have to come back 4 or 5 times just to see. So let's set this off maybe like 3 days, 4 days. Reach out to them and say, hey, we are going to subpoena you to come to court. If you guys, all we want to know is what's going on and whether you guys want to have contact and in-person contact as well. So ask everything so that you guys don't have to come back. Anticipate every single question that they're going to want known so that you can.
Yes, Judge.
So what we can do, so you don't have to waste your time coming to court. We can set it off 3 days, 4 days, and I'll waive your next appearance so you don't have to come here. And then she can reach out to you, phone that, because I don't want you to have to miss work or whatnot or anything. But I have to know what they want. And I don't want to work on speculation because
Is it what my son wants or is it?
it's what the son wants. I don't care what the guardian, I don't care who the guardian is. It's what the son wants. Right. I don't care about a guardian. It's not their decision. And I think that now what, 16?
16.
He's old enough to know, right? He's almost an adult, so he's old enough to make decisions on his own at this point.
And Judge,
Okay.
I've already accepted the PTI. We will get started on that. So even by this next setting where she doesn't have to appear, excuse me, Judge, she'll already be underway on the PTI.
Okay. Your parenting class is probably pretty short, so it's,
It's BIP and parenting classes, Judge. I'm sorry.
what is it?
It's BIP and a
Oh,
parenting class.
BIP and a parenting class. Okay.
I'm not really sure. I've got to figure out how long they want her in BIP and talk to her about that.
Got it.
So
Okay.
you can go sit down just for a second, then we'll get your case reset, okay?
Okay.
All right, we'll keep trying. Judge, I have one other one on docket today, and it's just a reset, and I've just been appointed today. Do I have to approach you on those? You've already found probable cause. It's Mr. Hall falsifying the drug
No,
test allegation.
no,
All right, then
no.
I'll just.
Just let him know that he's going to get drug tested about 50 days, just so
Sure.
he knows, and that's it.
Thank
Okay.
you so much.
Thank you, Mr. G.